Hey everyone, I got another compilation for you. I'm not sure how you feel about them, but I don't like to put out like 6-minute videos because you guys are used to a lot longer. So I threw some stuff together, some new ones, some old ones. They're all good. We're going to talk about ankle monitors today. There's two types of ankle monitors, the ones that just track where you are and what, like GPS, and then the other ones that track whether you have alcohol in your system or not. So people have some very interesting excuses for violating them, triggering the alcohol sensor. I mean, it's never because they drank alcohol. They didn't drink anything. See, I've got my Tito's earrings on. So let's take a look at some of the best excuses for triggering the ankle monitor. First up, we have Miss. It had to have been the Lysol, or the perfume, or the hairspray.
So we have an issue. The issue is they say that you're testing positive for alcohol, and they're saying that it was on October 3rd through October 5th. So what's going on with you? And before you tell me the story, number one, we're not on the record. This is just me getting your attention, right? Because you're on bond for an alcohol offense, and I can't have you testing positive for alcohol. You understand?
Yes.
All right. So what are you doing to address your problem?
Just a couple of things that might turn out to be alcohol. I don't think I'm on anymore. That's the thing, but they told me not to. I think I've abused that a little bit because I do some modeling, and I totally slipped my mind about that.
Excuse me, Ms. Martinez, could you speak up?
I'm so sorry, yes, because I'm thinking it could be the perfume or the hairspray, maybe. We do need to use Lysol. My son, he gets sick real easy, and there's like mold where I live, so we spray out Lysol. And it's been an issue having this leg monitor because, that's all I could think of, is those outside effects. I don't drink, I'm a Christian woman. I don't believe in making the same mistake twice. I have to suffer now for whatever consequences. But Your Honor, I did not drink any alcohol. I give you my word, God, my witness, that I have not drinking alcohol. You want to test me? You can.
Okay, I do. Let me just tell you, I do appreciate what you're saying, but I can't tell you the number of times that people have sworn to tell the truth, and then it turns out they're not telling the truth. So this is your third violation report. If there's a fourth violation report, what's going to end up happening is we're not going to have a hearing. They're going to take you into custody. All right, we have an issue with your client.
Yes, ma'am.
Your client's SCRAM says that there are violations.
Yes, that's my understanding. I haven't seen the report, but that's my understanding.
All right, so this is not on the record because this is a compliance hearing. According to this, you're continuing to use alcohol. No, I mean, you're saying negative, but I have a violation date of October 31st.
Judge, I told you, we talked about this last time. I made a promise to you that I wasn't going to use any perfumes, any Lysol.
Excuse me, could you speak up, please, Ms. Martinez?
I am innocent. In the name of Jesus, I'm innocent. I don't know why this thing keeps going off. I don't drink. I give you my word. My son's birthday is coming up on the 17th. I have children, Your Honor.
How about it was the vape? Now, to be fair, some vapes do have small traces of ethanol in it, which triggers that. But she would have to be smoking and then taking the test immediately afterwards every single time for it to constantly trigger like that.
I've spoken with Agent Mormon about it, and we haven't really come to a conclusion of what she thinks is triggering the positive test.
Oh, it's certainly not brushing your teeth.
No. She initially thought it was brushing her teeth. She now thinks it was a nicotine vape. That she was instructed to not blow 30 minutes before. She's been waiting 45 minutes and she hasn't had a positive test since changing that. So what I'm asking.
Why aren't I getting retest?
No. The reason why I did the retest the first couple of days was because I wasn't notified that the machine will actually tell me to retest. I thought that there was something that Mr. Mormon was gonna have to reset, like off site. So that is my fault and my irresponsibility for that.
Well, I suppose our explanation would be the vape issue. I mean, she maintains that she has not drank. She has this vape. She started using the vape when she was told at arraignment not to drink and not to consume marijuana.
Even if the vape has alcohol in it, which I don't think it would, but even if it does, she can't inhale or do anything with alcohol.
Yeah, I mean, I don't know why the vape would trigger the positive test. She's had continued positive at very small amounts. So that's our only explanation. I mean, she, again.
Here's the problem with that. The problem with that, even if you're talking a half an hour range, look at the very bottom of the report on the 16th. She submits a positive test at a 0.2, correct? There is then almost 20 minutes later, 18 minutes to be exact, there is a positive test. Again.
I don't have an explanation for it, Judge. I mean, if she was drinking, frankly, I don't know if we'd see that sharp reduction.
That's not a sharp reduction. That's a reduction.
I mean, going from 0.026 to 0.019 in 18 minutes, I don't know if it was alcohol.
Within the margin of error? Really, counsel?
I mean, she has consistently maintained that she has not drank alcohol. When she did have a positive test, she did an ETG and it was negative. So I think that explains that there's something else going on that she's consuming that we aren't aware of, that is triggering these positive tests.
Maybe it just malfunctioned. I mean, that's a thing, right? Or the hand sanitizer. I put hand sanitizer on my feet and ankles, don't you? Right?
That's based on some conversations between the victim in this matter and Ms. Collada that I was not able to be present for, but our advocate was. It's known, at least to the parties and the state's understanding, that these violations occurred at times when he was at work. The state does have concerns here, understanding that it is one violation. He has been compliant in other ways. The state is not seeking to modify his conditions of release at this time. However, the no contact order was rescinded over the state's objection on this matter, or I should say the state's objection on this matter, in order to have the SCRAM be a protective device. Now, setting aside the state's philosophical thoughts on that, the SCRAM is in place duly to restrict his use of alcohol and also, by the court's measure, to protect the victim in this place who no longer has a no contact order. It is troubling that even with the SCRAM device on, a violation has occurred when he's outside of the home, which to the state's mind is to elicit that activity, to attempt to withhold that information from the victim, who believes that Mr. Smigelski is actively seeking his sobriety. So the state's concerns here are such that we believe I'll leave it at that, Your Honor. The state would not be seeking any modifications of the SCRAM device other than to note the violation. But should future violations occur, we would be seeking for conditions of release modifications.
And you had said these occurred while he was at work, allegedly?
That's my understanding. It's not my personal knowledge. That's what I was told was conveyed via the victim to Ms. Collada. And then I was unable to attend because I was in court. But that's my understanding, is that the times at which the violations occurred are times when he was outside of the home.
Ms. Collada, Ms. Collada, the state just appears to be in position of reminding Mr. Smigelski of the importance of complying with the SCRAM device. And it was to his benefit that SCRAM was put on in exchange for the rescission of the no contact order. And so I think what they're saying is he runs the risk of the state requesting a reimposition of the no contact orders if there's any other violations. I guess I'll
Correct,
hear
Your
from
Honor.
you.
I think I would take the state's position as similar. However, I was actually speaking to Ms. Rachel Smigelski on Monday about these instances. And her position was that this SCRAM unit was actually giving false reports. She said that she is with Mr. Smigelski during the whole day and there's no alcohol in the house. And furthermore, she's been checking bank records to confirm that he's not spending money on alcohol. I would note to the court that the basis of this alleged violation is 0.011% alcohol. So it easily could have been detecting some kind of contaminant as simple as hand sanitizer. So I take the state's position with regard to the nature of that interview on Monday to be inaccurate. And I recognize Ms. Barker was not there, but it was very clear that Mrs. Smigelski is fully in support of Mr. Smigelski and fully agrees that he is abiding by the conditions of his release and is sober. So I just want to make that for the record.
All right. So, Mr. Smigelski, we're not going to adjust conditions of release at this time. But it's interesting. And again, we're not going to adjust conditions of release now. I hear Ms. Barker say, well, he heard she was at work. I heard what Ms. Collada said. Well, she's with him all the time. Then I read the, and maybe she goes to work with him. I don't know. But then on the submission from pretrial services per the phone conversation for Mr. Smigelski, he said he was asleep. So according to you, when you contacted pretrial services, they contacted you, according to them, you were asleep at the time. So all that, again, we're not going to adjust conditions of release. You don't need to worry about that. But I will be frank with you that all these conflicting stories kind of leave me scratching my head a little bit. And I was just going to leave it by reminding you, it's your responsibility to keep this. We have SCRAM on a lot of people, and many, many, many people get through it without a problem, without any sort of violation or positive reading. And I'm confident you can too, but it's your responsibility to do that. You understand that?
Yes, sir.
It was one of my other medications. I take a lot. Don't BS Judge Boyd.
All right. Yes, probation.
Judge, we're here regarding a compliance hearing that was stated on the supplemental report. Judge, the CSO requested allow removal of the GPS device, require compliance and progress of conditions within 60 days, otherwise set for a compliance hearing. So that's why we're here. It appears that since January, Mr. Torres really hasn't made much progress in regards to his conditions, to include providing proof of income, parenting class, victim impact panel, DWI intervention, sober support meetings, and affidavit of non-driving. He was instructed to submit UAs on 2 occasions, and he failed to submit those in February and in March. He did present a negative in April. However, today we did obtain a positive UA for cocaine.
For medication.
No, cocaine doesn't,
I take 18. Take Trazodone, Adderall, Seroquel, Xanax.
so you're saying there's a prescribed medication
No, I
out there
think
that,
I don't-
no, stop. You're telling me that there's stop chewing gum.
Oh, I'm sorry.
You're telling me that there's a prescribed medication out there that would give a false positive for cocaine?
Sure. I haven't
No.
done that. I haven't
No.
done that.
My question is that what you're telling me?
I'm not a doctor. I'm not sure. But Dr. Respect.
Well, here's my question. And you're not on oath. Have you used cocaine?
No, I haven't.
All right, so
I've been at home.
then the only other option is you're telling me that there's medication that will cause a positive for cocaine.
I'm not sure. I haven't even drank. I've been at home almost 3 months.
All right.
And I take 18 medications. I have all my papers from my doctor prescribed too. I haven't done nothing.
All
I
right.
haven't even drank.
All right, so I'm not removing it. I can't be removing GPS when somebody's testing positive for cocaine.
I don't know what to say. I just been at home almost
All right.
3 months.
So, I mean, it's
I
not getting
can't even step out
removed.
of the door, so,
It's not getting removed.
okay. But if you like, I could give you all the documents of my medication, like, I don't do it.
I don't know of any medication that will cause you to,
I don't know what it would do.
defense attorneys,
Sorry.
is there any medication that you all know of that would give me a positive for cocaine? Kanee's gonna come up with an answer.
Trazodone, Seroquel, Adderall, Xanax, I take a lot. Seroquel, I have all prescribed.
Here's the
medication.
thing, Seroquel
I have a
doesn't
drug
give,
mixed in me. I take them every day because I have
no,
anxiety.
that doesn't, none of those drugs give
I
you
don't know, I
false,
haven't done it. I haven't.
but this is what I'm telling you. You know, sometimes, I don't know everything. I don't pretend to know everything. Maybe there's a new medication out there. That's why I asked the defense
I'm not saying there
attorneys.
is, but I haven't done nothing. I've been in my house already almost 3 months. I can't go step out of foot, so.
Mhm.
I haven't even drank. I haven't even drank.
All right, probation, this is what the court is gonna do. I'm not removing GPS. And he's gonna be subject to the UA hotline. Here's the thing, if you have a drug or alcohol issue, guess what? We can work with you on that. I can figure out something that could help you with that. But I'm not removing GPS. And so we're gonna do the UA hotline.
What is that?
Yes. All right, and then I'm gonna, your TAP evaluation recommended outpatient treatment. So we're gonna do dual diagnosis. Outpatient treatment.
Then I've been getting random visits from the clubs, like they go like every.
And we're gonna do 120 sober meetings and 120 days.
Okay.
All right, so here's the thing. I want you to be successful on probation. If I didn't want you to be successful on probation, I wouldn't have agreed for you to be on probation. So you have got to be honest with yourself and look in the mirror and be honest with yourself. Guess what? Where you are now, hopefully this is not where you're going to end up, where you're positive for cocaine all the time.
Yeah.
All of us, me included, we're all trying to be better people and improve our lives, right? Nobody's perfect.
Yes, ma'am.
So you're going to have to not use drugs because you're on probation. You're not allowed to. Do you understand? And don't come before any other judge. If you're before a judge, telling them that you're positive for cocaine is because of your prescription medication. All right, do you understand?
Yes, ma'am.
All right, probation. Is there anything else? All right, good luck to you. If you need something, let the court know.
Some people think that they can prevent that awkward court moment where they get called out for, screwing up. They try to, mess with the monitor a little bit, maybe like put a towel between the monitor and their leg to try and keep it from working?
Violations.
I can. We've got 5 alcohol consumption events and 27 tamper events. Some of the tamper events were tampers with alcohol. Because SCRAM, if there's a tamper involved and alcohol, they categorize it as a tamper because they will not confirm an alcohol consumption with a tamper.
Okay, so, okay, that's quite a few violations and tamper events. And what can tamper events include?
So, tamper is anything placed between the skin and the unit itself. Because when the unit takes a reading, it's taking IR voltage, it's taking temperature, and it's taking alcohol. So if something's placed between the unit and the skin, the temperature changes, the IR voltage changes, and the device recognizes a tamper. I was tallying it. There was close to 20 of the tampers. 20 out of the 27 tampers were tampers with alcohol. With the tampers, depending on if it's just a tamper or if it's a tamper with alcohol, on the tampers, typically the first just tamper with no alcohol will warn the client to watch their clothing, make sure nothing's sliding between the unit and their bracelet. And then after that, we start issuing violations for any subsequent tampers after the first one that gets a warning.
Now this one, she was thinking outside the box. She was getting creative with it. Tinfoil.
I am puzzled as to why Ms. Robinson is incarcerated right now.
Okay, well, let me bring Mr. Murad in.
If I may, Your Honor.
You may.
So Judge, on June 15th, we actually had a tether violation hearing for Ms. Robinson. I don't know if the court remembers, but this is the case where Ms. Robinson put the aluminum foil on her tether.
Oh, yeah. Okay, I knew it was something. Okay, and then I said I wasn't, but I didn't, and then did I not give her, I didn't give her a personal bond either, did I?
I have bond condition amended to 1,000.
Then Ms. Robinson, when they have a tether available, they will let you out of jail, but you are on house arrest. Now, let me say this, put some more aluminum foil on a tether. I double dog dare you.
I double dog dare you.
I double dog dare you to put some more aluminum foil on a tether. And I'm gonna remand you again. I'm gonna remand you. I'm gonna remand, if you tamper with that tether, I'm gonna remand you to the Wayne County Jail.
Sometimes though, your SCRAM issues or GPS or ankle monitor or whatever you want to call it, it really is an accident. Sometimes things happen and, it was not intended at all. I don't think this guy meant to do what he did.
It's a brand new day.
But this, by far, is the wildest excuse I have ever heard.
Okay. As to the violation that you tampered with your GPS tether, how do you plead, sir? Okay, factual basis.
Thank you, Your Honor. Mr. Larson, do you remember when you were put on bond in this court that you were ordered to have a GPS tether attached to your leg?
Yes, Your Honor. Or yes.
And so on July 24th, at some time that day, did you come to realize that you did not have a tether on anymore?
Yes.
Do you know what happened to the tether?
I was out riding four-wheelers. I think it got stuck on something on the four-wheeler cut through the strap on the tether. I wasn't aware that it was even off at the time, but until after.
Right, but when you but when you did realize that you did not have this tether on anymore, did you contact JSG or the court or your attorney?
No, I didn't. I shouldn't. I was up in the UP because my father was dying and I'm his medical power of attorney, and I kind of freaked out and I'm taking full responsibility for it. I should have called. I didn't. I was arrested a few days later up there. I clearly was nowhere around the victim, and I sincerely apologize for my part that I played in it. I should have called and I didn't, and it was very stupid.
Okay, I'm not sure I understood what happened to the tether. You said it fell off?
I think the something on the side of the foot peg on the four-wheeler, there's a sharp piece that was hanging off of it, and I think it cut through it.
A sharp piece came off and it just cut through on its own?
No, I was out riding and it cut through it most of the way through the tether. And
So you
I
were out
freaked
riding?
Yes.
Is that what you said? Riding what?
Yes. Four-wheelers.
You were riding a Harley?
ATV?
I can't hear because of the echo. You were riding what?
ATVs, four-wheelers.
Oh, ATVs, and something from the ATV cut through it?
Yes, ma'am.
Oh, and you were unaware?
I was unaware, yes.
Did you ever see the tether after it fell off?
No, I didn't.
All right, so do you know you don't know how the tether fell off, truly?
No, but that's the only thing I can come up with because I tried to go back and look for it afterwards, but.
Okay, well then it sounds like that could have been a malfunction of the tether, so we'll continue to your hearing, and then we'll require the prosecutor to establish how the tether was dismantled from your leg.
The purpose of the GPS ankle monitor is to keep track of people before they are tried. It's like a pre-trial tracking program so they don't have to sit in jail, which is great. However, somebody has to pay for this, and if people are able, they are required to pay for it themselves. But if they don't pay for it, what happens? Well, one company decided they were going to repo their device. He's not paying for it, I'm taking it back. And I guess nobody seemed to think about the fact that they were tracking him for a reason.
It's been nearly 3 years
He worked as a security officer all his life.
since Hugo Garcia's father, Enrique, was shot and killed during a robbery that was caught on camera while he was on the job.
His life was tragically taken.
Despite a capital murder charge, accused killer Clint Walker was given a $100,000 bond this summer. That was enough to anger Garcia. Then he found out the GPS ankle monitor Walker was required to wear was removed when Walker failed to pay a monitoring fee that's a condition of his bond. Harris County District Attorney Kim Ogg raised her own concerns in this letter to court officials, calling the situation a, quote, troubling loophole.
Of course, this happened in Texas. There were statements put out that this was a violation of the contract that the county had with the individual contractor. They had gotten rid of the agreement with the contractor. It would never happen again, yada, yada. But who makes that decision to repo a GPS tracker from somebody accused of a crime? Like, who sits there and says, yeah, he's not paying, I'm taking that back? It is a strange world we live in. Make sure you pay for your ankle monitors. Don't get it repoed. Enjoyed this video, please take a moment, like, subscribe, leave me a comment, let me know. I will see you all soon.